Hello. In this video, I want to speak to you about mediation. Now, I've mentioned in the other videos how the Gauteng division has a new, it's new, it's been around for coming up to 2 years now, a directive that says that all civil matters, the parties have to attempt mediation before they can be allocated trial dates. So it's a good directive because what it means is the courts are trying to get parties to settle their disputes before they go into the court system, or certainly before they get weighed down in the court system. And there were a number of reasons why that came about, and specifically because there is such a massive backlog in the court systems. As I said in the previous video, for civil trial dates now, you're waiting approximately 5 to 6 years. So if you apply for a trial date now, you're probably going to be going to court in about 2030. So quite some time down the line. Mediation, on the other hand, can happen far quicker. And there are certain things about mediation that I think is very important that you know prior to going into mediation, and there's a lot of misconception about what mediation is and what it isn't. So I'm going to try and explain it to you in the best possible way that I can. Now, although this directive out of Gauteng says that you have to go to mediation first, mediation still remains a voluntary process. So you may be directed to go, you have to attend at least one mediation session, but the mediator that you select is still a choice between you and the other party to the dispute, and the decision that you ultimately come to, whether or not you settle, is still a voluntary choice. You get to make that decision. There's no court that's deciding the decision for you. So the mediation process is along the following lines. You and the other party to the dispute, there may be more than just the two of you, there may be 3, there may be 10, depending on the type of matter that you're involved in and that needs to be resolved. You will agree to attend mediation, or you will be directed by the court to attend mediation, and then you will decide between you who the mediator is going to be. And if you can't decide who the mediator is going to be, then that decision will be made on your behalf by one of the mediation organizations that, in terms of that Gauteng directive. But if you're not out of Gauteng and you're here in one of the other provinces, then you might agree that an organization will refer certain mediators to you, and you then decide which of those mediators you're going to choose. Now, the role of the mediator is to remain completely impartial. This is the most important thing that you need to remember about mediation. The mediator never, ever takes sides. This is a very different role to a judge or magistrate, or an arbitrator in the case of arbitration, who makes a final determination. So if your matter goes to trial, a judge or a magistrate is going to make a final decision about how your matter ends up. Who's right, who's wrong, who wins, who loses. That's one person getting to make that decision on your behalf. Mediation, on the other hand, you and the other person to the dispute ultimately get to make the decision, number one, whether or not you're going to settle, and number two, the terms of that settlement. So you remain in control of the outcome of the mediation. The mediator controls the process of how the mediation actually happens. So it's usually fairly standard formatting. but some mediators prefer different types of processes, and you will go with what your chosen mediator decides is the process. So, for example, I like to do what's called shuttle mediation, where I don't put the parties in the same room. I like to have them in different rooms because I just feel that when they are in different rooms, they feel more comfortable about sharing and speaking honestly and openly, whereas with the other party in the room, they may be a little bit reluctant to share certain things. So I prefer shuttle mediation, where the parties are sitting in different rooms. I also do virtual mediation, so I do it online. And with that, I'm able to do breakout rooms. Parties are in separate rooms, and I move between the rooms. So I'll go and speak to one party, and then I'll come out and I'll go and speak to the other party, and then I'll go back to the first party. There are mediators who keep the parties in one room, and they manage the process in that manner. With shuttle mediation, the mediator can bring the parties together in one room at times if they so choose, but it is the mediator who controls the process of the mediation. You can, when you appoint the mediator, ask for a specific type of mediation. So if you would prefer for there to be shuttle mediation, you can ask for that. And shuttle mediation is a very good way of doing mediation where there are large power imbalances. So this is very often done in family-related matters where there's a family dispute, or like a divorce, for example, or where it's an employer-employee, because obviously there is a disparity there, or where it's, for example, a large company versus a smaller company where there may be a power imbalance with regards to their financial clout, if you will. So those are things to consider when you decide on what sort of mediation process you would prefer. So mediation can also take place in sort of 2, 3, 4 hours, and then you come back on another day, or you can decide you're going to do a full half day or you're going to do a full day. It all depends on how you want that process to unfold and what the issues in dispute are. I've had matters where the parties have come to me and said they've settled, they just want me to help them draft the final agreement, and they send me all the agreements that they've already drafted, and 7 or 8 months down the line, they actually still haven't settled because there were so many issues that they actually hadn't even thought about or discussed that then came up during the mediation process. I've had other matters where the parties have had really big disputes and it appeared that there was no way they were ever going to settle, and 3 or 4 hours later they've settled because they were able to express themselves and had a safe space to do that. So the length of time that your mediation takes will all depend on your circumstances and the issues that are in dispute. But once you've reached an agreement, a settlement is then drafted, and very importantly, you have not reached agreement until that settlement agreement has been signed by everybody. If it is not signed, it's not an enforceable agreement until it is actually signed. So there may be certain aspects that you have provisionally agreed to, but until such time as you've signed a settlement document, no settlement has been reached. So just remember that. Another aspect about mediation that is sometimes misunderstood is that you can have legal representatives present with you if you choose to have them present. If a mediator says to you, absolutely not, I don't allow legal representatives present, and you prefer to have a representative present, find another mediator. Because that is your choice. If you want to have a legal representative with you during the mediation, you are entitled to do that. You have to understand that there is a cost implication to that, because obviously you have to pay the mediator and you have to pay your legal representative to be with you. But they can be there, provided the other party knows about it and the other party agrees that they too will have a legal representative present, or if they don't want one, then they can decide that they don't want one. That's entirely up to them. So those are sort of misconceptions about mediation that you may just want to be aware of. So the cost of mediation also differs depending on the experience of the mediator and the level of complexity of the matter, and also obviously the length of time that it takes for a matter to be mediated. If the matter is resolved in a couple of hours, it could be a few $1,000. If it takes a couple of months, it could be a few $100,000. But ultimately, mediation in general, and I am generalizing, there are very few matters that this won't be the case, is cheaper than litigation, and certainly quicker than litigation, simply because the court system is so jammed that getting trial dates is taking 5 to 6 years. So bear that in mind. Mediation is not going to take 5 to 6 years. Mediation is going to take anything from a couple of hours to a couple of months, and you will have an agreement that you and the other party or parties have agreed to, and you've been able to consider that agreement and come up with the best solution for your particular circumstances. That's the other great thing about mediation, is that you can kind of brainstorm alternative solutions to a problem that you hadn't considered before. And sometimes the mediator can come up with solutions that you may not have considered, because very often when you're looking from the outside in, you can see more than when you're looking from the inside out. So I hope that answers a few questions you may have about mediation. Importantly, it's voluntary, it's quicker, and most often cheaper than litigation, and a lot less stressful. Very often people who come to me for litigation matters say to me, I just want my day in court so that I can be heard. And I will say to them, you will be heard, but you are going to be cross-examined, number one. Giving evidence is always stressful, always, because the role of the other person's attorney is to make you make mistakes or contradict yourself, or show that you are an unreliable witness. And you've got a judge sitting there who may or may not understand your matter entirely, and who ultimately is going to come to a decision based on the evidence that is placed before him or her. And that, for me anyway, I wouldn't want somebody who doesn't know me, doesn't know my situation, doesn't know my circumstances, making a decision based on what they see and hear before them. I would far rather be empowered to make those decisions myself and to come to an agreement with the other party. And that is what mediation allows you. It's an empowering process, because it's not taking your personal power away from you. It's enabling you to come to the decision by yourself. And the other thing that's great about mediation is that it enables you and the other party to potentially repair and or maintain an ongoing relationship, particularly in circumstances where that is necessary. So you may, for example, be having a dispute with a business partner, and if you go to court, chances are that relationship is going to be destroyed. And whereas mediation, there's a good possibility that you may be able to repair that relationship and continue with the partnership or other business going forward. Another very important thing that I almost forgot is that you need to remember that matters that go before a court, except in the following circumstances, where there are children involved and domestic violence matters, all other matters are public. So anybody can have access to the files. Anybody can see the documents that are placed in a court file, anything. So if you've got a high profile business dispute where financial statements have to be put before the court and there are trial bundles with those in them and all that kind of thing, anybody from the public could potentially go and access those documents. Mediation, on the other hand, is confidential and it's completely without prejudice. So documents that are shared, things that are discussed, cannot be brought up in court proceedings unless they're things that are normally required to be discovered during the normal discovery processes. But if you exchange settlement negotiations and there are agreements that take place and things like that, all of that remains confidential forever. It doesn't come out into the public. Nobody's going to know about it. Nobody's going to get to see your dirty laundry. It remains between you and the other party, and obviously the mediator who is sitting there helping you to resolve that dispute. So I hope that was helpful. Thank you for watching.